Hello and welcome to this lesson on involuntary manslaughter. Involuntary manslaughter involves the unlawful killing of a human being under the Queen's peace, but there is no malice aforethought. So if you remember with murder, you have to have malice aforethought, which is the intent to kill or the intent to cause serious injury. And with manslaughter, there is none of the mens rea for the malice aforethought. So the sentence for involuntary manslaughter is a maximum of life in prison. Remember, with murder, it was a mandatory life sentence, so you had to get a life sentence. With manslaughter, this is a discretionary life sentence, so you can get up to life in prison. Equally, you could avoid prison, you could get a suspended sentence. So the judge will have a whole range of sentences, which is a good thing because there's a lot more flexibility. There are two types of manslaughter that we are concerned with. So we are going to be looking at what I call UDAM, which is unlawful and dangerous act manslaughter. And then we are going to be looking at GNM, which is gross negligence manslaughter. So two different types. What we'll do first of all is go through UDAM, unlawful and dangerous act manslaughter, and then we'll move on to gross negligence manslaughter. I will do a separate AO1 UDAM video and an AO3 and a separate GNM AO1 and AO3. So actually there are going to be 5 videos in total for involuntary manslaughter. Okay, so UDAM. This is basically where the defendant commits a crime and it results in a death. So for example, if you push somebody and they fall over and hit their head and they die, that could be unlawful dangerous act manslaughter. Now UDAM is set out in the case of Larkin, and it's nice, again, there's a good structure to this. So there are 4 elements. I do love structure because then you just think, right, all I need to do is remember 4 things, define them, chuck in a few cases, and you're good to go. So element number 1, the defendant must have committed an unlawful act. So it has to be an act. It can't be an omission, and that's the case of Lowe. That's where they failed to feed their child, and they said it's not UDAM. It could be the other type of manslaughter though, so don't think you get away with it. So it has to be an act, not an omission, Lowe. It also has to be a criminal wrong. It can't be a civil wrong. That's the case of Franklin. Sometimes it's actually quite difficult to prove the unlawful act. Remember, the prosecution have to prove it beyond all reasonable doubt. Now, if you can't prove an unlawful act, you can't have this type of manslaughter. You can't be guilty of UDAM. So the case of Lamb, the defendant and his friend, they were young, they were playing with a revolver, as you do, and they didn't think it would go off, but it did, and the victim died. Now, because they were messing around and they didn't think it was going to go off, there was actually no assault. The victim did not apprehend immediate unlawful violence. Therefore, because there was no assault, no unlawful act, it couldn't be unlawful act manslaughter. There is another case, I definitely remember Lamb, but if you want, you could remember the case of D. Now, it's called D because it's to do with a sensitive issue, so we sometimes don't name the defendants and the victims if it's a sensitive issue, because by identifying the defendant, you might identify the victim. So the victim killed herself after years of domestic abuse. On the evening she killed herself, the defendant had allegedly hit her, and he was convicted of UDAM by the jury. So he had hit her, she then went away and killed herself. So Court of Appeals said, we can't establish the unlawful act, we can't establish GBH on the night that she killed herself, so therefore we can't have unlawful act manslaughter. There are probably causation issues as well. There was a case once where somebody was raped and then they later killed themselves. So, have a think. Would that person be responsible for their death? Is that manslaughter? I think it's difficult to prove causation. The recent case or non-case of the woman who died, she was a railway worker, and a man spat at her at the railway station, and she contracted COVID and then died. Think about, is that unlawful act manslaughter. The unlawful act, spitting, is definitely an assault or a battery or both or criminal damage. But I think you might struggle to prove causation. But it's one to kind of, be mulling over. The other thing to think about is, so we know the unlawful act, it has to be positive, it's got to be criminal, you've got to prove the unlawful act. Who is the unlawful act directed to? It could be you, the victim, so you are pushed, you hit your head, you die, that's fine. Remember, think back to, I don't know, February, and we looked at transferred malice, probably even before then actually. The idea that, in the case of Mitchell, we looked at the case of Mitchell before, the defendant pushed somebody in a post office, they had an argument. That person, the old man, fell onto an old lady and she died. And the defendant was like, well, I didn't kill the old lady. It's like, no, you pushed the man, so that's a battery, that's your unlawful act. And that then led to the woman dying. So the unlawful act can be directed at a person, but that can then be transferred to somebody else. It can even be directed to property. So the case of Goodfellow, he's a bit of an idiot. Goodfellow wanted a new house, so he set fire to his council flat so that he could get a new one. And his wife and his son and another person died. He didn't really check properly that they would be able to get out, and they couldn't get out, and they died. He was guilty of UDAM. The unlawful act, he tried to claim, well, it wasn't directed at a person. It's like, doesn't matter. It was directed at property, so he was guilty. So, rightly so. That's all you need to know for element 1. Element 2, the unlawful act must be dangerous. Now, this comes from a case called Church. It's an objective test. So the test for dangerousness is, would a sober and reasonable person foresee the risk of some harm, albeit not serious harm? Dangerous, it's from a reasonable person's point of view, it's objective. We don't care if the defendant thought it was dangerous, it's you, the jury, a reasonable person. Is this dangerous? What does dangerous mean? It means the risk of some harm. Would a reasonable person foresee the risk of some harm? So, would a reasonable person foresee the risk of some harm from pushing somebody? Yes, they would. Now, the issue is, what does harm mean? Does it mean fear? Does it have to be physical harm? There have been 2 cases. The case of Dawson. So the facts of Dawson, 3 defendants attempted to rob a petrol station. Attendant managed to sound the alarm, but then died from a heart attack. They said in this case that causing fear was not a dangerous act, so it's not unlawful dangerous act manslaughter. Which I just think, I don't agree with this, because I think, why did that person have a heart attack? Well, they only had a heart attack because of the people robbing the petrol station. So did they cause the death? In my mind, absolutely. But yeah, Court of Appeal don't agree with me. So the conviction was quashed. The judge, there was misdirection from the judge, so the judge didn't direct the jury. They didn't say the right thing to the jury, because the judge had said you need to consider the victim's heart condition, and then they were like, well, actually no, a reasonable person wouldn't know that the attendant had a heart condition. So they're basically saying physical harm, it's got to be physical harm, fear is not included. That has now changed slightly with Watson. So in Watson, the defendant threw a brick through the victim's window. He was then assaulted by them, and the police were called, and he had a heart attack and died 90 minutes later. Now, the courts have basically said that burglary can be a dangerous act if, and it's a big if it is obvious that the victim is old or frail. So basically, if they had burgled the house of a 20-year-old and they'd had a heart attack and died, yeah, definitely not guilty, because there's no way you would, think that a 20-year-old would have a heart condition. However, if you went and did a robbery at an old people's home, then it is obvious that those people are old and frail. And if one of them has a heart attack and dies, you would be responsible. However, they ended up quashing the defendant's convictions because they couldn't decide, was it the police that caused his heart attack, or was it the burglars? And I'm like, Well, the police wouldn't, in my mind, I'm thinking the police wouldn't be there had the burglars not been there. But yeah, so I think Dawson and Watson, I think they're both guilty. But yeah, I'm not the Court of Appeal. I should be though, shouldn't I? So the church test, kind of now, it does include harm if it's obvious that the person is old and frail. There was another case that I just put in there because I thought this was an interesting one. And again, this is good if you have an essay because you can like discuss this and say, hang on a minute. So the case of Carey, the defendants made fun of the victim, pulled her hair, punched her in the face. She then ran off and died. So she was 15 and she had a heart condition. They didn't know about it. I don't know if she even knew about it. And she had a heart attack and she died. And the courts said the physical assault did not cause the death. So they'd been like, punching her, pulling her hair. They're like, no, that's not what caused the death. Her running away caused the death. And again, I'm like, well, why was she running away? She was only running away because she was being beaten up. So another decision. I don't agree with any of these. You could disagree with me. That's fine. But I think it's a really good one to discuss. And it goes against the crucial bit, I think, goes against the thin skull rule and the idea that you have to take your victim as you find them. It's good for you guys when the law is unsatisfactory and there are like inconsistencies, because that's really good in an essay. Okay, element 3, the Unlawful and Dangerous Act must cause death. This is normal causation. So factual causation, the but-for test, you use White or Paget. But for the defendant's actions, the end result would not have happened. And then you've got legal causation, so the defendant must play a significant part in the death. The case of Kimsey says that significant means more than a slight and trifling link, i.e. more than minimal, and there mustn't be any intervening acts. 2 examples that I wrote down: bad medical treatment breaks the chain of causation. That's the case of Jordan. And if you have a pre-existing medical condition or you refuse medical treatment, that won't break the chain, and that's the case of Blau. If you remember, that was our Jehovah's Witness who refused a blood transfusion, and that didn't break the chain. Now, one final thing to look at before we move on to element 4 is the issue of injecting drugs. So you've got to imagine 2 scenarios here. If I give you drugs, and so I prepare a mixture of heroin and water. I'm definitely not going to do that, but let's imagine I did. I prepare a mixture of heroin and water and give you the needle and you inject yourself and die. Am I guilty? The simple answer is no. But let's say you prepare the mixture of drugs and you say to me, oh, I'm really scared of needles. Please, can you inject me? And I decide to inject you. I'm like, okay, yeah, I'll do that. And then you die. Am I guilty? Yes. So the moral of the story is make sure the other person injects their own drugs, because that breaks the chain of causation. That is the case of Kennedy. So the defendant prepared the drugs, the victim injected themselves, and then they died. And the House of Lords said this is not unlawful dangerous act manslaughter. So the victim's free will of injecting themselves breaks the chain of causation. But had Kennedy also injected the victim, then Kennedy would have been guilty. So that's something, whether you agree with that or not, think about that one. And then the final element of UDAM is the defendant must have the mens rea for the unlawful act. So, if you push somebody, you've got to have the mens rea for pushing. So the mens rea for battery, you have to intend to apply unlawful force. Goodfellow, his unlawful act was arson. So you've got to prove that he intended the arson or was reckless about the arson, which is quite easy to prove. If you can't prove the mens rea for the unlawful act, then obviously you can't have, if any of these elements fail, then it's not manslaughter. The case of Newbury and Jones, you've got 2 boys who pushed a paving stone over a railway bridge. This hit a train, killed the guard, and the House of Lords said as long as you have the mens rea for the unlawful act, which I guess here was criminal damage perhaps, then that's enough. So that is unlawful dangerous act manslaughter. The next type of manslaughter to look at is gross negligence manslaughter, so GNM. This is where the defendant has a duty of care and then they breach it in a grossly negligent way and the victim dies. So it's a bit different to UDAM. One of the sentence, exactly the same, all that kind of stuff. And the other difference, though, is that it can be committed by an act or an omission. So I would recommend you go back and look at your omissions stuff that we did when we did actus reus for paper 1, because lots of those duty of cares are relevant. The first thing to say about gross negligence manslaughter comes from a case called Adamaco. This is where the defendant was an anaesthetist, difficult word to say and spell, and they failed to notice the victim's oxygen tube was dislodged. The victim had a heart attack and died, so they upheld the defendant's conviction. So the anaesthetist was guilty of manslaughter. Element 1, defendant must owe the victim a duty of care. So this is a civil concept. If you think back to duty of care, you've got the neighbour test from Donoghue and Stevenson. Your neighbour, you owe a duty of care to people closely and directly affected by your acts or omissions. Examples of duty of care, so you've got Adamaco, doctor-patient, Lowe, parent-child, Pitwood is a contractual duty, Stone and Dobinson, where you voluntarily assume responsibility. You've done all of these cases. Gibbons and Proctor, special relationship. Singh was a landlord of a property in which a faulty gas fire, I think it leaked carbon monoxide and the tenants died, and the landlord owes a duty of care. That would probably come under a contractual duty, so Pitwood. You've then got an interesting case. It's not the one that's currently going on at the moment, which is also very similar but interesting. But the case of Wacker, defendant brought 60 illegal immigrants into England and 58 of them died in his lorry. He claimed he was transporting tomatoes, which, yeah, have a look. It's on the BBC website. His name's Perry Wacker. Defendant argued that because he was doing an illegal activity, when he finally admitted it, he said, I don't owe a duty of care because it's illegal. How can I owe a duty of care? And they turned around and said, the court said, it is manslaughter. Even if it's an illegal activity, you still owe a duty of care. Rightly so, 58 people died because of him. You've then got the case of Evans. There's a great clip, I'll have to try and find it for you, but Evans, the mother and half-sister of the victim, gave the victim some heroin for her 16th birthday. She became ill, which apparently she had done lots of times before, so that means she was taking heroin when she was like 14, 15. So they didn't phone 999. They're used to her being a bit ill on heroin, and they put her to bed, and she died. The court said they're both guilty of gross negligence manslaughter. They owed her a duty of care and they'd breached their duty because they had not called 999. So I think rightly so. So element 1 is you owe a duty of care. Element 2, the defendant breaches that duty. Now you have to compare the defendant to a reasonably competent equivalent. So you would compare the defendant, if they had let their child run off and the child had drowned, to what would a reasonably competent parent have done? Or if the lifeguard wasn't watching, what would a reasonably competent lifeguard have done? What would a reasonably competent doctor have done if it's a medical case? So a doctor is judged against a reasonably competent doctor, a parent against a reasonably competent parent, a teacher against a reasonably competent teacher. And your case for that is Bateman, and this was a doctor. It was years ago, like nearly 100 years ago, and the doctor attended a home birth, and the woman became really ill, and he didn't send her to hospital, and she later died. And they said another doctor in that situation would have done the same thing, so he's not guilty. That's what you need to know for element 2. Element 3, there has to be a risk of death, and death must be caused. So risk of death just comes from the case called Misra. Misra had a knee operation, or sorry, Misra is the defendant, but the victim had a knee operation. 2 doctors failed to give proper post-op care, and they were convicted of gross negligence manslaughter. So basically, the point of law you need to know from Misra has to be a risk of death from the defendant's act or omission. Then normal causation rules, yet again. So factual causation, but for test, case of White or Paget, but for D's actions, the end result would not have happened. Legal causation. So you have to play a significant part in the death. Kimsey says significant means more than a slight and trifling link, more than minimal. No intervening acts. So an intervening act would break the chain, like very bad medical treatment. Jordan doesn't break the chain if you refuse medical treatment. Blau. And then the final element is element 4. The breach is so gross that it's criminal. So basically that means the negligence, what the person did or didn't do, is so bad that they should be classed as a criminal. Bateman says there must be behaviour which shows such disregard for the life and safety of others as to be deserving of punishment. And Andrews says there must be a very high degree of negligence. So it's a nice structure, 4 elements for both types of manslaughter. I think in an exam question, you wouldn't be asked both types. So what I'll do is I'll do the AO1 and the AO3 for each type of manslaughter because I think they would separate it. So watch those videos to help